If you are pursuing Italian citizenship iure sanguinis, you have probably heard that the new March 2025 citizenship reform was a death sentence for cases beyond the second generation. Under the strict text of the new Article 3 bis, many families were told their claims were officially barred. But is that actually true? Just today, a specialized court in Naples issued a groundbreaking decision that completely bypasses the new generation limits. They ruled that if you did everything in your power to book an appointment before the reform took effect, the law cannot punish you for the Italian government's own broken booking system. In this video, I will break down the exact evidence this family used to win, the legal precedent that makes this possible, and a crucial warning about why the entire landscape is still wide open and could shift in the next few weeks. If you're new to this channel, ciao, I am Avvocato Michele Vitale. Every day at my firm ItalyGet.com we help international clients navigate Italian citizenship and litigation to successfully claim their heritage without the standard bureaucratic headaches. Here is our roadmap for today. First, we'll look at the exact facts and the secret weapon on the May 18 Naples ruling. Second, the higher court legal structure that made this victory possible. And third, the massive upcoming dates in June 2026 that will decide if this ruling remains a solid pathway or a temporary exception. Let's talk about the case. On May 18, 2026, the Specialized Immigration Section of the Naples Court recognized a family of US-based petitioners as Italian citizens. They were fourth-generation descendants. Under the strict text of the new Law 74/2025, they should have never approved. So how did they win? Their legal team, brilliantly led by Avvocato Michele Ambrogio from the ILF law firm in Florence, who served as the dominus and lead counsel on record for the petitioners, presented a very specific, verified electronic trail. I was proud to collaborate with Avvocato Ambrogio's firm on the defense strategy in advisory capacity. The secret weapon, the petitioner, had documented proof of svariati tentativi, countless booking attempts on the notorious Prenot portal, followed immediately by email requests sent to their local Italian consulate in the US back on August 2024. Because those attempts were made months before the March 2025 reform deadline, the judge ruled that they had effectively initiated the process in time. And here is a massive procedural detail. The Ministry of Interior chose not to appear in court. They defaulted, which in Italian law is called contumacia. Because the ministry defaulted and did not contest the facts, the court ruled that the documented Prenotami screenshots and emails stood as uncontested, binding evidence of their attempt to apply. Before we look at the higher court rulings that back this up, a quick pause. If you are preparing a citizenship case, or if you have been blocked by the consular booking system and need a specialized, legally sound defense strategy, head over to ItalyGet.com and book a consultation with my firm. We analyze your specific bloodline and consular records to build a robust judicial appeal. Now let's look at the legal architecture behind this Naples ruling. The Naples judge didn't pull this reasoning out of thin air. It stands on two massive pillars from higher courts. First, on April 30, 2026, the Constitutional Court in Sentenza 63 upheld the reform overall, but explicitly left unresolved the question of people who started their application attempts but never received an appointment before the deadline. Naples stepped right into that open door. Second, on May 12, the Supreme Court of Cassation published Ordinanza 13818, stating that standing to sue exists if government obstacles or consular malfunctions make it impossible to even submit an application. But I must urge extreme prudence. This is not a settled trend. While the Naples ruling is a highly encouraging victory, other courts in Italy, like Brescia, Ancona and Bologna, have been rejecting similar post-reform cases on the merits without waiting for higher guidance. Meanwhile, courts in Rome, Venice and Caltanissetta have suspended all proceedings, waiting for the higher courts to issue a final word. And here is a development published just today, also on May 18th, the same day as the Naples ruling. The Court of Genova has issued a suspension order in its own pending case, scheduling a new hearing for June 19th. Why? Because the Genova judge is explicitly waiting for both the Constitutional Court session of June 9th and the Sezioni Unite ruling from the Cassazione. But there is something critically important in the Genova order that you need to hear. The Genova judge distinguishes the specific case from the many others he is handling, precisely because this petitioner has produced documented evidence of consular appointment attempts. He's not deciding yet, but he is already drawing the same evidentiary line that Naples drew today. The Genova judge also sets a hard deadline. Due to the Italian PNRR constraints, this court must issue its decision by June 30, 2026, whether or not the higher courts have ruled by then. The two decisions that will truly reshape everything are coming very soon. On June 9, 2026, the Constitutional Court will specifically address the gap between appointment received and process initiated but no appointment given, a question formally referred by the Court of Mantova and Campobasso. In addition to that, the Sezioni Unite of the Cassazione are expected to issue one monumental ruling which could also decide on the scope of Article 3 bis, which will bind every lower court in the country. Until those decisions are published, every favorable merits ruling, like this one, represents a temporary window, not a guaranteed outcome. So, to recap, the documented Prenot screenshots and emails from August 2024 were ruled sufficient to satisfy the deadlines in Naples. 2. Genova, on the very same day, issued a suspension order in a similar case, waiting for June 9th and the Sezioni Unite ruling, but explicitly noted that this petitioner has at least some documentation of consular attempts. Third, June 9th is the date every citizenship judge in Italy is watching. After that, nothing will be the same. Now you know how Naples and Genova are handling the reform, but as I warned, the legal battle is highly volatile. While Naples accepted consular attempts, other courts are doing the exact opposite. In fact, 6 major rejections just dropped from Brescia and Bologna, and they explicitly rule out the Prenot screenshots that won in Naples. To understand the real risks your case faces and see exactly what these hostile judges are writing, click on the next video on your screen right now, where I break down all 6 rejections in detail. Click that video, Italian. Ci vediamo lì. Ciao!